Chapter 15. The Battle of the Booksellers in Britain. 1. The Stationers' Company and the 1662 Licensing Act. Before the concept of intellectual property was ever whispered in the corridors of Westminster, the British book trade was ruled by a shadowy, iron-fisted monopoly known as the Stationers' Company. This wasn't a gathering of creative minds, but a powerful guild of master printers and booksellers who held a royal charter dating back to 1557. However, it was the Licensing Act of 1662 that elevated this guild from a mere trade association to a formidable arm of the state's repressive machinery. This act was the ultimate enclosure of the alphabet, turning every printed word into a potential crime and every book into a piece of private territory. Under the 1662 Act, the great theft of knowledge was formalized through the mechanism of the register. No book could be legally printed, sold, or even possessed unless it was entered into the stationer's register. Crucially, this entry, the original copyright, didn't belong to the author who bled ink onto the page, but to the member of the guild who owned the physical manuscript. Once a title was registered, it became the perpetual property of that stationer. It was a fence that never came down. If a printer owned the copy to Shakespeare or Milton, he owned it forever, and his heirs could collect rent on those words until the end of time. The 1662 Licensing Act was in reality a cynical pact between the Crown and the cartel. The king needed a way to suppress the heretical and seditious pamphlets that had fueled the English Civil War, and the stationers wanted to eliminate competition from upstart printers outside of London. The state granted the guild a total monopoly on the press in exchange for their services as moral and political cleaners. The stationers were granted the right of search, the authority to burst into any workshop, break open crates, seize unlicensed presses, and burn illegal books in the streets. In this suffocating environment, the goddess of justice was replaced by the master of the guild. This explores the gritty, ink-stained corridors of London's Paternoster Row, where the great theft was enforced not by judges, but by a corporate police force. The 1662 Act ensured that ideas were not free-floating sparks of enlightenment, but strictly licensed commodities. If a thought didn't have a landlord in the Stationers' Company, it was an outlaw. This was the era of total intellectual enclosure, where the English language itself was treated as a private estate and the public's right to read was entirely dependent on the profit margins and political loyalty of a handful of London booksellers. 2. The Statute of Anne, 1710, as a three-way bargain. By the dawn of the 18th century, the iron-fisted monopoly of the Stationers' Company began to fracture under the weight of its own tyranny. The Licensing Act had expired, and for a brief, chaotic moment, the fences around the English book trade collapsed, allowing a flood of unofficial printers to challenge the London elite. Panicked and desperate to reclaim their territory, the London booksellers, the self-appointed lords of the press, rushed to Parliament. They didn't ask for censorship this time. They asked for property. What they received instead was the Statute of Anne, 1710, a document that would become the Magna Carta of intellectual property. It wasn't a simple act of protection, but a cynical, brilliant, and fragile three-way bargain between the state, the booksellers, and the public. To win over the legislators, the booksellers employed a masterful rhetorical mask. They placed the author at the front of their campaign. They painted vivid, heartbreaking pictures of poor, starving writers whose genius was being pilfered by greedy pirates. This was a Trojan horse. The booksellers had no interest in the welfare of authors. They knew that a writer, often living in a cold garret and desperate for his next meal, would immediately sell his legal rights to them for a pittance. The Statute of Anne officially granted the sole liberty of printing to the author, but it added a revolutionary condition that sent a chill through the guild. For the first time in history, the great theft was given an expiration date. The bargain functioned as a delicate mechanical balance. First, the author was recognized for the first time as the legal font of the property, a moral victory that provided the creator with a title deed to their thoughts. Second, the booksellers gained a legally enforceable monopoly that was recognized by the courts, but it was a term of years, 14 years with a 14-year renewal, rather than a perpetual empire. Third, the public, the silent third party, gained the most profound promise of all, the public domain. The law stipulated that once the clock ran out, the fence must be torn down, and the work must return to the common soil of humanity, free for any citizen to print, read, and share without tribute. This was the moment the intellectual world accepted a hard truth. Ideas were not like acres of land. While a landlord could hold a field through generations of bloodlines, a thought owner could only hold a monopoly for a season. The Statute of Anne was a legal ceasefire in the war over the mind. It institutionalized the enclosure of ideas, yes, but it also built a timer into the lock. It ensured that while the great theft could continue for a generation, the ultimate destiny of every book was to belong to everyone. This explores how this law turned the stationer's privilege into the public's lease, creating the modern tension between private profit and the collective inheritance of human knowledge. 3. Milton's Areopagitica and the just retaining of copies. To understand the moral soul of the resistance against these monopolies, we must retreat to 1644, a time of civil war and spiritual upheaval, when the poet John Milton penned his fiery masterpiece Areopagitica. While modern history often remembers this work as the foundational pillar of free speech, its relationship to the great theft of property is far more complex and intimate. Milton wasn't merely fighting for the right to speak, he was launching a preemptive strike against the state's attempt to own the very conscience of its citizens through the machinery of the Stationers' Company. In a passage of hauntingly descriptive power, Milton argued that a book is not a dead commodity like a bale of wool or a cask of wine. He wrote, "Books are not absolutely dead things, but do contain a potency of life in them to be as active as that soul was whose progeny they are." To Milton, the enclosure of the press was a form of intellectual homicide. By requiring a license from a guild before a book could exist, the state wasn't just protecting property, it was slaying an immortality rather than a life. However, Milton was no anarchist. He made a crucial, nuanced distinction that would echo through copyright law for centuries. He defended the just retaining of each man his several copy. This phrase is the seed of the moral right. Milton believed that a writer's work was the issue of the brain, an organic extension of the self that no government should be able to seize or suppress. He viewed the author's right to his work as a protective shield, a way for the creator to maintain the integrity of his ideas against the stifling hands of the royal censors and the greedy manipulations of the London booksellers. For Milton, the great theft wasn't just about the loss of silver, but the theft of the spirit. He loathed the Stationers' Company because they used the concept of property as a cage, ensuring that no truth could reach the public unless it was profitable and politically safe for the guild. By framing the book as a living, breathing entity, Milton provided the philosophical weaponry for future generations to argue that while a printer might own the physical ink and paper, the truth within belongs to the spirit of the creator, and by extension, to the common heritage of man. He envisioned a world where ownership served the truth, rather than the truth being enslaved to the owner. 4. Donaldson versus Becket, the end of perpetual rights. The tension between the limited term of the Statute of Anne and the eternal greed of the London booksellers finally reached a cataclysmic breaking point in the landmark case of Donaldson versus Becket. For over 60 years following the 1710 Act, the London publishers had lived in a state of open rebellion against the law. They claimed that even if the Statute of Anne had expired, they still held a common law right that lasted forever. They viewed books like a hereditary estate. Once you enclosed the rights to Shakespeare, Milton, or Chaucer, They were yours and your heirs until the end of time. These lords of literature used their immense wealth to terrorize any upstart printer who dared to produce a cheap edition of the English classics. They argued that intellectual property was a natural right identical to land ownership. But in 1774, the House of Lords delivered a verdict that shattered the perpetual fence forever. They ruled that copyright is a creature of statute, not a natural, eternal law of nature. When the timer set by Parliament runs out, the work must, by necessity, be unfenced. This was a monumental moment of deprivatization. For the first time, the great theft was legally reversed on a massive scale. The Lords declared that the greatest works of the English language were the property of no one, and therefore the property of everyone. The verdict signaled the death of the perpetual monopoly. It established the revolutionary principle that the public domain is the natural state of human culture, and any private enclosure is merely a temporary lease granted by society for the encouragement of learning. When the gavel fell, the classics were liberated from the high-priced velvet-lined stalls of the London cartel and delivered into the hands of the common people. 5. The Scottish challenge to London monopolies. The true heroes of this intellectual liberation weren't the London judges, but the Scottish booksellers. In the mid-18th century, printers in Edinburgh and Glasgow, led by the defiant and shrewd Alexander Donaldson, launched a full-scale economic war against the London stationers. These Scots were the original disruptors of the property system. They realized that by ignoring the Londoners' illegal claims to perpetual ownership, they could print high-quality, low-cost editions of the greats and flood the English market. The Battle of the Booksellers was essentially a war between two visions of property. The Old South, monopoly, which wanted high prices and exclusive permanent control, and the New North, accessibility, which wanted volume, competition, and public benefit. Donaldson even had the audacity to open a shop in London, right in the heart of the enemy's territory, selling books at half the official price. He famously argued that the Londoners were tyrants of the press, who were starving the minds of the poor to fatten their own ledgers. This Scottish challenge was the first real victory for the public domain in practice. By treating the classics as a shared heritage rather than a private estate, the Scots turned the logic of the great theft on its head. They proved that when the walls of monopoly are torn down, culture doesn't disappear. It breathes, spreads, thrives. The victory of the Scottish pirates ensured that the English language would never again be the private property of a London clique, setting the stage for the mass literacy and the democratic spread of knowledge in the 19th century.